Conditional residency and removal of conditions process. Once the I-526 petition is approved, the second step in the pathway to legal permanent residence in the employment-based fifth preference category is to file for continual permanent resident status. An immigrant investor can do this if outside the United States via consular processing or, if in the United States, via the adjustment of status process. Under either process, an immigrant investor's dependents can apply for CPR status concurrently with or after the immigrant investor, not before. In order to do this, the principal applicants and all of their dependents must each file 1. If the EB-5 investor already has lawful status in the United States, then they must file Form I-485 to adjust their status to conditional permanent resident. 2. If the investor does not already have lawful status in the United States, then they must file for an immigrant visa by submitting Form DS-260 to the National Visa Center, and they must process through the U.S. consulate or embassy in their home country. Let's explain the Form I-485. What is the I-485 application? Once the I-526 petitions are approved, immigrant investors can adjust their status within the United States to become U.S. conditional permanent residents. In order to do this, the principal applicants and all of their dependents must each file an I-485 petition. This form is only for EB-5 investors that are already in the United States. Components of the I-485 application. There are several requirements that EB-5 applicants must satisfy to have Form I-485 accepted by the USCIS. We recommend investors to consult an immigration attorney who will assist with the following requirements: applicant's criminal history, examples of evidence, official statements from law enforcement agents, court orders, and probation records, a valid birth certificate, marriage certificate, and all divorce certificates. Examples: copy of foreign birth certificate, copies of other suitable birth records, copy of passport pages and non-immigrant visa, photocopies of complete passport, all immigrations-related documents showing maintenance of U.S. status, biometric services if applicants are between the ages of 14 and 78. USCIS notifies applicants of where they must obtain their biometric services after Form I-485 has been submitted. Biometric services include fingerprinting, the applicant's photograph and signature. Medical examination. Examples: medical examination reports and vaccination records. Biographic information. Those between 14 and 78 years of age must submit a completed Form G3258. Evidence of eligibility. A copy of Form I-797C that the EB-5 applicant received upon the approval of the I-526 petition, filing the I-485. The I-485 application is often filed by immigration attorneys on behalf of the EB-5 program applicants. I-485 applications can be filed as soon as the I-526 petition is accepted. The investors has to fill a fee for the I-485 application and a fee for the biometrics requirement. The processing time for I-485 application varies depending on the USCIS file offices. Applicants are notified by the USCIS by email or physical mail after their applications have been processed. However, EB-5 applicants can obtain work and travel authorization while their I-485 application is being processed if they file an I-765 application for employment authorization and I-131 application for travel document. EB-5 applicants become two-year conditional permanent residents once their I-485 application has been approved. 2 years after the applicant becomes a conditional permanent resident, the I-829 petition is filed to remove conditions and the EB-5 investor becomes a full permanent resident after the I-829 is approved by the USCIS. This enables the investor, their spouse, and unmarried children under the age of 21 to permanently live and work in the United States. Now, let's explain Form DS-260. What is the DS-264 application? Well, EB-5 visa applicants who are not already in the United States upon approval of their I-526 immigrant petition by alien entrepreneur, or upon notification that the visa is available based on their I-526 petition approval, will have to file the online DS-260 application to obtain conditional permanent residency status during their third step of the EB-5 visa process. The DS-260 is filed by EB-5 investor processing at the U.S. consulate or embassy abroad. The conditional permanent residency status that is given to the EB-5 investors after their DS-260 is approved enables them and their dependents to move to the United States. An EB-5 immigration attorney can help file the DS-260 application. Visa applicants provide biographical information on the DS-260 application. Applicants must also provide a list of all previous residencies, job history for the past 10 years, and military service information. The applicant may require to bring documentation such as marriage certificates, birth certificates, and passports to their DS-260 interview. Separate DS-260 applications must be filed for each family member who will accompany the EB-5 investor to the United States to become permanent residents. Thanks for watching. For more information, check our other videos.